The trustee.
Sir, you need to stop. You're being in contempt of court. You need to stop, or I'll have the officer assist you in stopping. All right, Missy.
False imprisonment.
I want you to stop talking, or you can go upstairs to the county jail. Now, do you want to go to jail tonight? The second.
I also have a right to understand the nature of this. I have a right to understand the nature of.
If you don't want to listen to me, you can go to jail.
I'm not being disruptive. I'm just trying to understand the nature and cause of the charges.
All right, officers. I'm gonna close.
What am I doing? I'm sitting here trying to understand the charge.
If he gives any more grief.
Your Honor, can I please go home? Your Honor, can I please go home? I'll leave.
Today we are looking at one of the most unbelievable sovereign citizen courtroom moments that has appeared on this channel. The man standing before the court is facing charges related to driving without proper insurance and also speeding on the road. Despite the seriousness of the situation, he behaves as if the entire hearing is some kind of casual conversation. Instead of treating the courtroom with respect, he speaks to the judge in a relaxed and argumentative tone, as if they are friends debating something trivial. This is not a casual gathering, and the consequences of the case could include serious penalties, including time in custody. Throughout the hearing, he continues speaking in long, confusing statements that sound impressive but rarely connect to the real issue in front of the court. His explanations move from one idea to another and make the situation even more difficult to follow. The judge listens carefully while trying to guide the discussion back to the actual charges and legal facts. As the exchange unfolds, it becomes clear that the man believes his unusual arguments will somehow change the outcome. Moments like this show how quickly a courtroom can turn tense when someone refuses to address the real legal problem. Now let us take a closer look at the hearing and see how this situation develops as the judge responds to the claims being presented.
Mr. Johnson, appearing in person and pro se. Your name tag on your uniform says Johnson, so I presume you are Mr. Johnson. Now, sir, if you could get right in front of that microphone. Thank you.
Can you hear me?
I can. Sir,
yes.
You're charged in count 1 with speeding 82 miles per hour in a 65 mile per hour zone. That is a traffic infraction. It is not a charge that carries any jail time. It has a scheduled fine. 82 and a 65 is $87, but then there's also 108 court costs. In count 2, you're accused of operating your motor vehicle without proof of insurance. Now, if you had insurance but just couldn't find it, you can get the proof to the county attorney and she'll probably dismiss that charge. If, in fact, it had lapsed or something was happening so that you didn't have insurance on the vehicle at the time being January 4th, 2024, that is a B misdemeanor. The maximum penalties as far as jail time would be 6 months, although probation is usually granted. There is a mandatory minimum fine the court must impose of $300, but it could be as high as $1,000. You do have the right to hire any attorney of your choice. If you cannot afford an attorney, you can apply and see if you qualify for court appointed. You can waive your right to counsel and represent yourself. Another option, you might be able to apply for diversion. That is where you apply, and if the county attorney approves you for diversion, you would pay agreed upon fines, costs, get your insurance current, and pay a diversion fee, and she'd dismiss the charges and keep them off your record. If you want to talk about diversion or anything else with your attorney, you certainly will have the opportunity to do that. Your pleas, you have a choice of pleas. You can plead not guilty, and we can set this for trial at a later date. You can plead guilty, admitting the charge, and we would proceed with sentencing. Or you could plead no contest, which is neither admitting nor denying the charges, but you'd still most likely be found guilty and we'd proceed to sentencing. If you want to look into diversion, we'll enter a not guilty plea to give you time to do that. You can always change your plea, but once you're convicted, pre-trial diversion is off the table. So
Just probably not eligible for diversion based on his driving record.
oh, okay. Well, do you want to talk to an attorney then and discuss whether or not you have a defense? Or?
No, Your Honor, I would like to request a declaratory judgment due to there is no agreement for my performance under any agreement or commission of this court.
Well, I don't need an agreement from you, sir. So if I were...
Well, Your Honor, I simply do not understand the nature and cause of the accusation with regard to the jurisdiction of the venue and nature of this action until the prosecutor properly alleges them there. I cannot enter a plea to the charge until I have the opportunity to raise a meaningful defense on my behalf.
You can almost see the tension slowly rising on the face of Judge Jo Webster as the hearing continues, and her patience begins to wear thin. The man in front of her seems convinced that long, confusing speeches about freedom and jurisdiction will somehow solve his legal problem. He keeps repeating complicated-sounding phrases as if it carries special power inside the courtroom. In reality, the law is very clear about the situation when someone is driving without proper insurance or without a valid license. These rules are straightforward and they apply to everyone who uses public roads. No complicated speech or unusual interpretation of the law will change that basic fact. The arguments he continues to present only make the discussion more frustrating and difficult to follow. It raises the question of how someone becomes so certain that they exist outside the normal legal system. Many observers wonder where these ideas begin and how they spread so widely among different people. Some believe the information may come from online videos forums or other unreliable sources that promise simple solutions to complex legal issues. Unfortunately, those ideas often fall apart the moment they are tested inside a real courtroom. As the exchange continues, the man becomes more intense and the situation begins to escalate even further. Now the tone of the hearing shifts as his behavior grows more confrontational toward the judge.
All right, I will then, since you cannot enter a plea today, I will enter a not guilty plea for you and give you
I
time.
object, Your Honor. I object to you entering a plea to me because I must understand the nature and cause of these accusations. So I do not agree to you entering a plea on my behalf.
Well, your position is taken and I'm still going to do it. I will note your objection for the record, but I'm going to enter a not guilty plea.
Well, I object to you entering
Your
a plea
objection
on my
is
behalf.
noted. Your objection is noted, and if the time comes, you can appeal that to the Court of Appeals. Now, on the issue
Well,
of
who is,
attorney,
Your Honor, I would like to ask, who bring these charges against me? I should have the right to
all
question.
right, we're not going to have this debate right now. I've told you your charges. I've told you the state of Kansas has filed those through its attorney, Jill Gillette. Now,
Well, I would like to call
I'm
the
going
state to the. I would like to call the state to the stand, Your Honor.
We're not doing
the
that,
state bringing charges against me. Who is it? How did I injure the state?
All right, this is your first appearance. I advise you of your rights. I advise you of your charges and possible.
Your Honor, I object to the proceeding, for I do not know the nature and cause of the
I'm
proceeding.
entering a not guilty plea. Missy, when is
I object to you entering I object to you entering a plea on my behalf. I do not grant you that right.
Missy?
The court
You're supposed to act as a trustee.
Sir,
of-
you
No.
need to stop. You're being in contempt of court. You need to stop or I'll have the officer assist you in stopping. Missy?
Well, Your Honor, I would like to also bring to you
September
according to
27th.
USC 12203.
Deputy Miles.
And also
you,
Article 3, the judge must operate in good faith and good behavior. So therefore, if you're making a threat towards me, then
Deputy,
that's
if he's going to
urging
keep
me to
being
perform in your
contentious, I'm going to
court.
have you take him into custody on contempt.
Then that would be illegal search and seizures, Your Honor.
Wouldn't you need to go back?
It will.
All right,
It's
Missy.
false
I
imprisonment.
want you to stop talking or you can go upstairs to the county jail. Now, do you want to go to jail tonight?
Your Honor, again, Title
Deputy
40,
Miles, could you
let's
come in and
see.
assist the defendant?
September 27th at 9 o'clock will be the court date.
September 27th, you said 9 o'clock?
Yes.
9 a.m. You must be back here, sir. in person at the courthouse, or you will be arrested for failure to come to court. Now, that deputy there is going to take you into custody if you cannot control yourself through the remainder of this hearing.
I'm not doing anything. I'm just enforcing my right, Your Honor.
All right, so your first right is to have a hearing date, and that is September 27th, 9 a.m. The second
Your Honor, I also have a right to understand the nature of this.
This man truly seems unable to recognize the signals being given by the court as the hearing continues. Many people watching might feel that the situation has already gone far beyond normal courtroom behavior. If someone else were in the judge's position, they might have already issued a contempt warning because of the constant interruptions and refusal to listen. Credit must be given to Judge Joe Webster for remaining calm and maintaining control of the courtroom while the discussion becomes more difficult. The man repeatedly claims that he has the right to understand the nature of the charges against him. In principle, that idea is correct because the right to be informed of charges is an important part of due process under the Sixth Amendment. However, the judge has already explained the charges clearly more than once during the hearing. Instead of accepting the explanation, he continues acting as if the court is hiding information or conducting something improper. This reaction creates a strange situation where clear answers are given but completely ignored. At this stage, the issue no longer seems to be about understanding the law, but about refusing to accept the explanation that has already been provided. The judge continues to show patience while guiding the hearing forward despite the repeated challenges. Now the real question becomes how long this patience can last before the court decides to take stronger action.
I have a right to understand the nature of the cause.
If you don't want to listen to me, you can go to jail. Do you want to hire an attorney or apply for court appointed?
No, I do not. I don't need to hire an attorney, Your Honor.
You want to represent yourself?
I don't need to hire an attorney. I would like for you as the judge, Your Honor, to explain to me the nature and cause of these.
All right, I'm not going to appoint an attorney if you don't want me to. If you want, you said you don't want to hire an attorney. If you want to apply for court appointed, the officers have forms there that you can fill out.
I just want to understand the nature and cause.
If you don't want to fill one out, I'm going to assume you don't want an attorney. And then if you come to court September 27th at 9 a.m., you're going to be representing yourself if you don't hire or apply for court appointed. And so you've got the third issue. Does he have a bond? Looks like you do because you failed to appear on February 27th at your first appearance. So bench warrant was issued, bond was set at $1,000 cash for professional surety. Looks like that was posted. Looks like you made a cash bond of $1,000. Does that sound right? You put up $1,000 cash back in July 12th?
I'm still trying to understand the nature and cause of this allegation, Your Honor.
I will continue your bond unless you get yourself hauled into jail on contempt before you leave. I will continue your bond with the condition that you reappear here in person at September 27th at 9 a.m. So you've got your court date, you've got your bond, and we've talked about your lawyer. Now, you're wearing a U.S. Army uniform with the name Johnson on it. Are you in or have you been in the United States military?
Your Honor, I'm still trying to understand the nature and cause of the allegation, Your Honor.
All right. If you can leave the courthouse now without any further disruption, I will let you do so. But I'm going to have those officers escort you to make sure you do so. So, Mr. Gillette, anything further?
Your Honor, it is your oath to explain the nature and cause of the allegation against me. Are you failing to do that?
All right. You can either walk out the front door with the officers, or you can walk upstairs to the county jail with the officers.
Share your thoughts about what might happen next as this situation continues to unfold inside the courtroom. The man has been given several chances to simply follow the judge's instructions and calmly leave the building. At this moment, the outcome could still move in two very different directions depending on the choice he makes next. He could cooperate and bring the hearing to a close, or he could continue speaking and risk facing immediate consequences from the court. The judge has already delivered multiple warnings, and each one was a clear opportunity for him to step back and resolve the moment peacefully. Instead, he keeps returning to the same prepared lines as if repeating them will somehow change the result of the hearing. The situation becomes even more surprising when it is mentioned that he previously served in the Army, which is an institution built on strict rules and discipline. That background makes the current behavior seem even more unusual to many observers watching the exchange. It raises questions about how someone with that experience would approach a courtroom with such resistance to authority and procedure. Whatever the explanation may be, the tension inside the room continues to rise as the judge waits for the next response. Now the moment approaches where the court will decide how to move forward depending on the choice he makes next.
Choice is yours. Either leave
Yeah, I'm trying to understand.
or leave disruptively.
I'm not being
That's why an
disruptive. I'm
attorney
just
can
trying to
help.
understand the nature and cause of the
All right,
charge.
officers, I'm gonna close
What
it.
am I doing? I'm sitting here trying to understand the charge.
If he gives any more grief,
All I'm asking is to understand the charges. This is
I've
for
told
the
you the
record. You said
charges.
it's for the record, so I'm trying to understand what am I being
I'll do
charged?
the charges. Goodbye, sir.
I just want to understand the nature and cause of the charges, Your Honor. That's all I ask. It is your
I've
oath
gone
to
over
give
those
that.
with you. If you tell me what kind of questions you have, I'll be happy to answer them, but I've already told you.
Okay. Under what jurisdiction is these charges being brought to me under?
The state of Kansas has charged you with speeding 82 and a 65 and operating a motor vehicle without liability insurance on January 4th, 2024 in Greenwood County, Kansas. You failed to appear for your first appearance and a bench warrant was issued and you were arrested and you made a bond of $1,000 cash or surety, posting a cash bond. Now you have to go to court and you have to answer those charges. You can
Your Honor, I
have
know.
a trial if you like, and the burden will be on the state of Kansas to either prove or disprove. If they can't prove it beyond a reasonable doubt, you're let go.
Well, I'm still trying to understand what jurisdiction am I being charged under, Your Honor? That's all I'm trying to understand.
You're being charged under the jurisdiction of the state of Kansas under its criminal law.
But according to the Constitution, there are only two
All right,
jurisdictions.
we'll have that on a later date. We'll be at recess, officers. Please escort him one way or the other, depending on his behavior.
But I'm still not understanding what you're charging me with.
Goodbye. We are adjourned.
But if she's the judge, I'm supposed to have clear and concise of what I'm being charged with. I'm not giving y'all a problem. I'm trying to. Well, I'm waiting on the Your Honor to explain.
All right, Missy.
But that's it.
That's our last case on the docket, isn't it?
This is not good.
Yes.
All right. All right. Ms. Gillette, I'll see you at 3:30 docket.
Your Honor, can I please go home? Your Honor, can I please go home? I'll leave.
All right. Well,
Can I go home?
I left it up to them and I left it up to you and then they were to behave accordingly.
This courtroom situation stands out as one of the most unusual cases many viewers have ever witnessed. The man involved seemed almost determined to create a path that would lead directly towards serious consequences rather than resolving the issue calmly. The judge carefully explained the charges and the authority of the court using clear and simple language so there would be no confusion. Even with that explanation, the message did not appear to fully reach him or change his approach during the hearing. His behavior reflected a strange mixture of strong confidence and a belief in ideas that do not match how the legal system actually works. The result was a long and exhausting exchange that left the courtroom dealing with arguments that had little connection to the real charges. Situations like this often create a larger problem because they consume valuable court time and energy that could be spent addressing other important cases. Judges, clerks, and legal staff must pause their regular work to handle these disruptions while other matters wait in line. This process also requires public resources, which means the entire system must carry the cost of hearings that move far away from the real legal issues. For those who work inside the courtroom, it can be frustrating to manage arguments based on theories that have no support in established law. At the same time, the judge in this case showed patience by giving several opportunities for the man to cooperate before taking stronger action. In the end, the hearing became an example of how courts try to balance patience with the need to maintain order and respect for the law. Now it is interesting to hear how others view this case, and whether they believe the judge handled the situation effectively. If you found this courtroom breakdown interesting, feel free to share your thoughts and stay tuned for more discussions about unusual legal moments like this one.